Registers. The provisions relating to maintaining the various registers as per the Companies Act 2013 are contained in Section 88 to 91. Along these provisions, the Companies Management and Administration Rules 2014 are also applicable to the maintenance of registers by a company. Various provisions relating to keeping and maintenance of registers are as follows. Section 88 Register of Members and etc. Register of Members Rule 3 from MGT 1. Register of Debenture Holders any other security holder Rule 4 from MGT 2. Maintenance of Register of Members etc. Rule 5. Index of Names of Members Rule 6. Foreign Register Rule 7 from MGT 3. Section 89 Declaration IRO beneficial interest in any share. In respect of beneficial interest in any share. Rule 9 Form MGT 4, MGT 5, MGT 6. Section 90 Register of significant beneficial owners. Section 91 Power to close register of members of debenture or holder or other security holders. Rule 10 Procedure for closing the register of members, debenture holders and other security holders.
ये कल अपन ने पढ़ा था, याद है ना? लाइक 1 2 3 4 5 6. ठीक है, तुम लेक्चर देखोगे तो समझ जाए.
Register of members, etc. Section 88. Section 88, 1 of the Companies Act 2013 requires that every company shall keep and maintain the following registers. Register of members holding of each class of equity and preference shares of each member residing in or outside India shall be shown separately in the register. Register of debenture holder DH and register of any other security holders. Maintenance of register of members. Every company limited by shares shall, from the date of its registration, maintain a register of its member in form number NGT 1, Rule 3, 1. However, in case of a company existing on the commencement of the Companies Act 2013, the particulars as available in the register of members maintained under the Companies Act 1956 shall be transferred to the new register of members in form number MGT 1. In case additional information required as per the provisions of the Companies Act 2013 and the rules made thereunder is provided by the members, such information may also be added in the register and when provided. In case of
ये समझा ना तुम? 1956 का डेटा इसमें ट्रांसफर करेंगे.
In case of a company not having share capital, the register shall contain the following particulars in respect of each member. Name of the member, address, register office address in case the member is a body corporate, email address, permanent account number or corporate identity number, CIN, nationality. In case member is a minor, name of his guardian and the date of birth of the member, name and address of the nominee. Date of becoming the member, date of cessation, amount of guarantee if any other interest if any, and instruction if any given by the member with regard to sending of notices etc. However, in case of a company existing on the commencement of the Companies Act 2013, the particulars as available in the register of members maintained under the Companies Act 1956 shall be transferred to the new register of members in form number MGT1. In case additional information required as per the provisions of the Companies Act 2013 and the rules made thereunder is provided by the members, such information may also be added in the register as and when provided. Maintenance of register of debenture holder or any other security holder. Every company which issues or allots debenture or any other security shall maintain a separate register for a debenture holder or security holders, as the case may be, for such type of debenture or other security in form MGT 2. Other requirements applicable to all registers. Rule 5 contains certain requirements which are applicable to all types of registers, that is, register of member, register of debenture holder, and register of any other security holders. These are stated as under. Time period for making entries in register. As per Rule 5.1, entries have to be made in the register within 7 days of the date of approval by the Board of Committee, thereby approving the allotment or transfer of shares, debenture, or any other security as the case may be. According to Rule 5.3, consequent upon by forfeiture, buyback, reduction, subdivision, consolidation or cancellation of share, issue of sweat equity shares, transmission of shares issued under any scheme of agreement, mergers, reconstitution or employee stock option scheme or any such scheme provided under this act or by issue of duplicate or new share certificates or new debenture or other security certificates, entry shall be made within 7 days after approval by the board of or committee in the register of member or in the respective register is the case may be. Place of maintaining register. According to Rule 5 of 2, the register shall be maintained at the register office of the company unless a special resolution is passed in the general meeting authorizing the keeping of the register at any other place within the city, town, or village in which the register office is situated, or any other place in India which more than one-tenth of the total members entered in the register of members reside. Other information also be referred in register. In terms of Rule 5.6, if any order is passed by any judicial or revenue authority or by Security and Exchange Board of India or competent authority attaching the shares, debentures, or other securities and giving direction for remittance of dividend or interest, the necessary reference of such order shall be indicated in the respective register. According to Rule 5.7, in case of companies whose securities are listed on a stock exchange in or outside India, the particulars of any place, charge, lien, or hypothecation created by the promoters in respect of any securities of the companies held by the promoter, including the names of pledged phony and any revocation therein shall be entered in the register within 15 days from such an event.
ठीक है। ये समझा ना तुमको? अगर किसी का शेयर्स अगर पढ़ते ही हो ना,
In case of companies whose securities are listed on a stock exchange in or outside India, the particulars of any pledge, charge, lien, or hypothecation created by the promoters in respect of any securities of the company held by the promoter, including the name of pledge pony and any revocation therein shall be entered in the register within 15 days from such an event.
समझा ये?
According to Rule 5.8, if promoter of any listed company which has formed a joint venture company with another company have pledged or hypothecated or created charge or lien in respect of any security of the listed company in connection with such joint venture company, the particulars of such pledge, hypothecation, charge, and lien shall be entered in the register of members of the listed company within 15 days from such an event. Updating of charge in status
चार्ज
of
नहीं, चेंज।
change in status of members. Rule 504 states that if any change occurs in the status of a member or debenture holder or any other security holder, whether due to death or insolvency or change of name or due to transfer to an investor education protection fund or due to any other reason, entries thereof explaining the change shall be made in the respective registers. Rectification in register. According to Rule 505, if any rectification is made in the register maintained under Section 88 by the company pursuant to the any order passed by the competent authority under the Act, the necessary reference of such order shall be indicated in the respective register. Index of names. Section 88(2) provides that every register maintained under Section 88(1) shall include an index of names included therein. However, according to Rule 6 of the Companies Management and Administration Rule 2014, the maintenance of index is not necessary where the number of members is less than 50. Rule 6 also provides that the company shall make the necessary entries in the index simultaneously with the entry for allotment or transfer of any security in such register.
मेंटेनेंस ऑफ इंडेक्स नॉट नेसेसरी है, रजिस्टर नहीं। 50 से कम रहेगा तो कल पढ़ा था। 50 ही लिखे, देख ले, देख ले, पढ़ा है।
Register and index of beneficial owners being maintained by a depository. Section 88(3) is an enabling provision which sets out that the register and index of beneficial owners maintained by a depository under Section 11 of the Depository Act 1996 shall be deemed to be the corresponding register and index for the purposes of this act. Foreign register section 88(4) read with rule 7. Maintenance of foreign register. A company which has share capital or which has issued debentures or any other securities may, if so authorized by its articles, keep in any country outside India a part of the register of member or debenture holders or of any other security holders or of beneficial owners resident in that country. The register shall be called foreign register. Other requirements relating to foreign register. In case a company decides to keep a foreign register, it shall comply with the following requirements. Filing of notice of the situation of the office within 30 days from the date of the opening of any foreign register. The company shall file with the registrar of company notice of the situation of the office where such register is kept. The notice shall be filed in form number MGT3 along with the requisite fee. Filing of notice in case of change or discontinuance. In the event of any change in the situation of such office or of its continuance, the company shall within 30 days from the date of such change or discontinuance, as the case may be, file notice in form number MGT3 with the registrar of companies of such change or discontinuance. Foreign register part of company's register. A foreign register shall be deemed to be part of the company's register to be called principal register or member of or debenture holders or of any other security holders or beneficial owners as the case may be. Format of foreign register. The foreign register shall be maintained in the same format as the principal register. Inspection, etc. of foreign register. A foreign register shall be open to inspection and may be closed, and extracts may be taken there from then copies thereof may be required in the same manner as is applicable to the principal register. However, advertisement before closing the register shall be inserted in at least 2 newspapers circulating in the place wherein the foreign register is kept.
ठीक है, फॉरेन में ऐड करना है मैं, याद है ना?
उसमें वो वर्नाक्यूलर और इंग्लिश वर्नाक्यूलर
लेक्चर देख आगे।
decision of the appropriate competent authority binding in regard to the rectification. If a foreign register is kept by a company in any country outside India, the decision of the appropriate competent authority in regard to the rectification of the register shall be binding. Making of entries in foreign register. Entries in the foreign register shall be made after the board of directors or its duly constituted committee approves the allotment of transfer of shares, debentures, or any other securities as the case may be. Transmission of a copy every entry. Transmission of a copy every entry. The company shall transmit to its register office in India a copy of every entry in any foreign register within 15 days after the entry is made.
वो अपन ने बैकअप वाला पॉइंट लिखा था ना, मैं 15 दिन लिख दो चेक कर।
Keeping of duplicate foreign register at register office. The company shall keep at the register office a duplicate register of every foreign register duly updated from time to time. Duplicate foreign register to be part of principal register. Every duplicate foreign register shall be deemed to be the part of the principal register for all purposes of the Companies Act. Transaction not to be registered in any other register. No transaction with respect to any share or as the case may be, debenture or any other security registered in a foreign register shall during the continuance of that register be registered in any other register. Transfer of entries on discontinuation. The company may discontinue the keeping of any foreign register and thereupon all entries in that register shall be transferred to some other foreign register kept by the company outside India or to the principal register. Penalty for failure to maintain register in accordance with the provisions of section 88(1) and 88(2). If a company does not maintain a register of member or debenture holders or other security holders or fails to maintain them in accordance with the provisions of subsection 1 or subsection 2, the company shall be liable to a penalty of 3 lakh rupees and every officer of the company who is in default shall be liable to a penalty of 50,000 rupees.
थोड़ा आगे
Nature of offense. The offense under this section is a compoundable offense under section 441 of the Act. Details of nominations in the register. It is important to note that Form MGT1 and MGT2 requires details of nominations. Nomination is referred to in section 72 of the Act. Read with the Rule 19 of the Companies Share Capital and Debenture Rule 2014 to be entered in the register of member and register of debenture holder or other security holder as the case may be. Authentication of entries Rule 8. The entries in the register maintained under Section 88 index included therein shall be authenticated by the company secretary of the company or by any other person authorized by the board for the purpose, and the date of the board resolution authorizing the same shall be mentioned. The entries in the foreign register shall be authenticated by the company secretary of the company or person authorized by the board or by appending his signature to the entry. Illustration 1. Lakshmi Hairstyles Private Limited allotted 500 shares in the name of Mr. Zoe's daughter, Mila, who is 4 years old. Mr. Zoe, the director of the company, has approached you to advise him to the entries to be made in the register of members since Mila is incompetent to contract in her capacity as minor.
बताओ
वो तो बार
उसने माइनर के नाम पे रख दिया चलेगा नहीं उसने गार्डन के नाम सिंपल है और
Since minor are not competent to enter into any contract, their names cannot be entered in the register of member without the details of guidance. Therefore, Mr. Joey is advised that while filing NDT1, the name of a minor shall be entered only if the details of the guardian are available. Thus, Joey's name shall also appear in the register of member of Luxy Hairstyle Private Limited since Mila is a minor. Illustration 2. Tanya and Tarun, who recently got married, were jointly allotted 1,000 shares by New Hospitality Service Private Limited. Tarun intimated the company that only the name of his wife should appear in the records of the company in respect of joint holding of share allotted to them. The directors of the company are not sure whether this is possible, given that the share are held in the names of both Tanya and Tarun.
बताओ
नहीं चलेगा
वाइफ का भी नाम रखना पड़ेगा दोनों का नाम मैंने लिखा है तो जॉइंट केस में दोनों का नाम लिखने का but
joint holders of shares may request the company to enter their name in the register in a certain order or
तो पहले किसका लिखना है वो बताएंगे बट दोनों का लिखेंगे
or execute transfer to have their holding split. With the result, their part of the holding is entered showing the name of one of holder and the part showing the name of other holder. However, the condition of Tarun that only the name of his wife Tanya should appear in the register as a member cannot be accessed to. Although the names can be entered in the order such that the name of his wife appears first. The reason for this is that the articles of most companies provide that in case of exclusion of the other joint holder and for his purpose, seniority shall be determined by the order in which the names stand in the register of members.
बेनिफिशियल का याद है ना 456
Declaration in respect of beneficial interest in any share, Section 89. Section 89 of the Companies Act 2013 contains provisions relating to declaration of beneficial interest in any share. Rule 9 of the Companies Management and Administration Rule 2014 provides for procedural aspects.
इधर ये पढ़
Members not holding beneficial interest in the share of a company, Section 89(1). Any person holding beneficial interest in the shares of that company, Section 89(2). Any changes in the beneficial interest of persons making declarations, Section 89(3), shall file a declaration of beneficial interest within 30 days, and company shall also file a return with ROC in 30 days.
ये याद है ना तुमको बहुत अच्छा था ये फॉर्म नंबर कौन सा था
Declaration by
फोर पे कौन करता है
Declaration by registered holder or shares. A person whose name is entered in the register of member of a company as the holder of shares in that company, but who does not hold the beneficial interest in such shares, hereinafter referred to as the registered owner, shall file with the company a declaration to that effect in form number MGT4, specifying the name and other particulars of the person who holds the beneficial interest in such shares. The declaration MGT4 shall be made within a period of 30 days from the date on which his name is entered in the register of member of such company. Section 89(1) and 89 Rule 9(1).
ये समझा ना मैंने क्या बना है?
हाँ. Declaration by person holding beneficial interest in shares. Every person who holds or acquire a beneficial interest in share of a company shall make a declaration to the company in form MGT5 within 30 days after acquiring such beneficial interest.
ये 30
Specifying the nature of interest particular of the person in whose name the shares stand registered in the books of the company and such other particulars as may be prescribed section 89(2) and rule 9(2). Declaration in case of change in beneficial interest wherein any change occurs in the beneficial interest in any if shares in respect of which a declaration has been filed under section 89(1) by the registered owner and under section 89(2) by the beneficial owner, then within 30 days of such change, a declaration is to be made to the company. Filing of return by the company with the registrar, wherein the declaration under section 89 is made to the company shall make a note of such declaration in the register concerned and shall file within 30 days from the date of receipt of declaration by it a return in form number MGT6 with the registrar in respect of such declaration with P section 89(6) and rule 9(3). Consequence of non-filing of declaration. Where a declaration required to be made under section 89 is not made by the beneficial owner, then any right with respect to such share shall not be enforceable by the beneficial owner or by any person claiming through him. Section
समझा ना
89.
ये?
हाँ.
फिर एग्जेम्पशन किसको था? म्यूचुअल फंड, क्योंकि उसका काम नहीं हुआ.
Rule 9 shall not apply to a trust which is created to set up a mutual fund or venture capital fund or such other fund as may be approved by SEBI. Accordingly, such entities need not file the declaration as envisaged by this rule. Duty of the company to pay dividend not
डिविडेंड
affected.
किसको जाएगा? आरओ को नहीं जाएगा.
Nothing contained in this section shall be deemed to prejudice the obligation of a company to pay dividend to its member under this section, this act, and the said obligation shall, on such payment, stands discharged. इसका क्या मतलब है सर?
एक्चुअली नेक्स्ट.
Meaning of beneficial interest. For the purpose of section 89 and section 90, beneficial interest in a share includes directly or indirectly through any contract, agreement, or otherwise the right of entitlement of a person alone or together with any other person to exercise or cause to be exercised any or all of the rights attached to such share or receive a particular participate in dividend or other distribution in respect of such share. Section 89(10). Exemption from the provisions of section 89, section 89(11), the central government may be notification exempt any class or classes of person from complying with any of the requirement of this section except subsection 10 if it is considered necessary to grant such exemption in the public interest, and any such exemption may be granted either unconditionally or subject to such condition as may be specified in the notification.
गवर्नमेंट के पास क्या हथियार है? पब्लिक इंटरेस्ट. कभी किसी कंपनी को एग्जाम करना है, कर सकता है. गवर्नमेंट कंपनी का देख ले.
Exemption to a government company. In case of government company, section 89 shall not apply. Notification number GSR 463E dated 5th June 2015. The above mentioned exemption shall be applicable to a government company which has not committed a default in filing its financial statement under section.
उधर गवर्नमेंट कंपनी भी चाहिए तो ऐड कर दो नोट्स में. कल एक सेक्शन पढ़ा है तो नोट से ही पढ़ना बोला था, वो नोट से ही पढ़ना. एक बार अपन ट्राई करेंगे पढ़ने का. नो डिफॉल्ट, हाँ, वो वही दो चीज में। अरे हाँ ना। उनको समझा ना किधर लिखने का है?
137 or annual return under section 92 with the registrar, notification number GSR 582E dated 30 June 2017. Penalty for default, section 89(5) and 89(7). Two kinds of penal provisions as described below are included under section 89. Relating to default made by persons required to make a declaration. If any person fails to make a declaration as required under subsection 1 or subsection 2 or subsection 3, he shall be liable to a penalty of 50,000 rupees, and in case of continuing failure with a further penalty of 200 rupees for each day after the first, during which such failure continues, subject to a maximum of 5 lakh rupees.
आरओ या बीओ अगर नहीं दे रहे एमडीटी 45 में, तो उसको कितना पेनल्टी लगेगा? 50,000। कंटिन्यूइंग डिफॉल्ट रहेगा तो 200 पर डे। लेकिन मैक्सिमम कितना रहेगा?
5 lakh.
और कंपनी का कितना है? पढ़ दो ऐसे।
Relating to default made by a company, if a company required to file a return under subsection 6 fails to do so before the expiry of the time specified therein, the company and every officer of the company who is in default shall be liable to a penalty of 1,000 rupees for each day during which such failure continues, subject to a maximum of 5 lakh rupees in case of a company and 2 lakh rupees in case of an officer who is in default.
समझा तुमको ये पेनल्टी? कंपनी और कंपनी के केस में कौन लायबल रहेगा? कंपनी एंड ओआईडी। ठीक है। कंपनी और इसको कितना है?
1,000 पर डे.
ठीक है, 1000 पर।
ठीक है.
कंपनी को मैक्सिमम कितना है?
5
लाख। और इसको कितना है?
2 लाख.
2 लाख। अभी तुमको पढ़ने आते हैं धीरे धीरे। इसे आके पेपर लिखा घर पे? पेपर लिया था टेस्ट, किसी ने जाके लिखा वापस घर पे? कष्ट किया क्या? आंसर आंसर भी मैंने बताया था किधर से क्या पूछा है। किसी ने कष्ट किया कि मैं एटलीस्ट एक बार देखूं, देख के पेपर लिखूं तो मेरा प्रैक्टिस हो जाएगा। कोई खुद से गया? प्रियंका नहीं? क्यों? ऐसा सूझा नहीं तेरे को कि चलो थोड़ा मेहनत कर लेते? अपना भी लॉ में जैसा आंसर है फिर वैसे ही राइटिंग प्रैक्टिस आए। सब बताने का तुमको, खुद से कुछ नहीं करेंगे तुम लोग।
Register of significant beneficial owners.
बैठ जा अभी दूसरे पास। अरे यहाँ आ जाओ। तुमको समझता है ना पढ़ के? पढ़ के समझता है ना? ये सेक्शन कल किया था।
Register of significant beneficial owners in a company, Section 90. As per Section 90 of the Companies Act 2013, every significant beneficial owner is required to disclose the nature of his interests or other particulars within the prescribed period of time to the company, which in turn will inform the same to the registrar of companies. In this connection, MCA has issued the companies SBO Rules 2018, which deals with identification and reporting in connection with SBO.
समरी बना था ना लास्ट में, उसमें बेन 1 2 3 भी ऐड कर दो बाद में। पर
Definition of significant beneficial owner. The term significant beneficial owner SBO has been defined in Section 90 of the Act as every individual who, acting alone or together or through one or more persons or trust, including a then and persons resident outside India, holds beneficial interest of not less than 25% or such other percentage as may be prescribed in shares of a company, or the right to exercise or the actual exercising of significant influence or control as defined in clause 27 of section 2 over the company. However, the companies has amended the definition of the term SBO in terms of Rule 21 H of the SBO rules, the term SBO is defined as an individual who
इस सेक्शन 272 है, उसमें वो सिग्निफिकेंट मतलब 25% वो लोग मान, लेकिन बाद में एसबीओ का ये लोग ने रूल ही निकाल दिया, तो इतना रेलेवेंट नहीं है, इसलिए मैंने लिखा नहीं था।
acting alone or together or through one or more person or trust process
10 था पता है, 10 पर मोर देन इक्वल टू 10% ऑफ वोटिंग पावर, फिर मोर देन इक्वल टू 10% ऑफ मतलब शेयर्स, डिविडेंड आता है 10% से ज्यादा और सिग्निफिकेंट इन्फ्लुएंस।
through one or more person or trust possesses one or more of the following rights or entitlements in the reporting company, that is the company in respect of which SBO declaration is required to be filed, holds indirectly or together with any direct holdings not less than 10% of the shares, holds indirectly or together with any direct holdings not less than 10% of the voting rights in the shares, has the right to receive or participate in not less than 10% of total distributable dividend or any other distribution in a financial year through indirect holdings alone or together with any direct holdings, as the right of to exercise or actually exercises significant influence or control in any manner other than through direct holdings alone.
इन सिंपल टर्म बोलो क्या बोलिया।
In simple terms, SBO is an individual who, either alone or together with other individuals or trusts, exercises the rights to entitlements in the reporting company by the way of holding 10% share or 10% voting rights, or rights to receive 10% or more dividend, both indirect or direct holdings, or right taken together, or such individual exercises significant influence or control indirectly or along with direct holding in the reporting company. The amended rules further explain that if an individual does not hold any indirect right or entitlement as mentioned in 1, 2, or 3 above, will not be considered to be as SBO. Significant influence. The term significant influence was previously not defined specifically for the rules, and hence to provide clarity, the following definition has been inserted through SBO rules. Significant influence means the power to participate directly or indirectly in the financial and or operating policy decisions of the reporting company, but is not control or joint control of the policies.
समझा तुमको? सिग्निफिकेंट इन्फ्लुएंस मतलब क्या, तुम्हारे बिना मतलब तुम्हारा भी चलता है। मेजोरिटी स्टेक फंड,
Majority stake. The
ये सबको एक एक को डिफाइन किया है, ठीक है, पर
majority stake. The amendment rules inserted a new term, majority stake, which means holding more than one half of the equity share capital in the body corporate, or holding more than one half of the voting rights in the body corporate, or having the right to receive or participate in more than one half of the distributed dividend or any other distribution by the body corporate.
तो एक बात बता, 10% होल्ड करता है तो ही आ जाता है, तो हाफ तो आ ही जाएगा, बराबर ना? हाफ मतलब कितना होता है? 50%। पढ़ा
Direct and indirect shareholding. The amendment rules provided that when an individual holds any rights or entitlement directly in the reporting company, the said individual shall not be considered as SBO. An individual will be considered to hold a right to or entitlement directly in the reporting company if he satisfies any of the following criteria: the shares in the reporting company representing such rights or entitlement are held in the name of such individual. The individual holds or acquires a beneficial interest in the shares of the reporting company under Section 89(2) and has made the declaration in this regard to the reporting company. Indirect shareholding is when a shareholder A shareholder is a body corporate, Hindu undivided family, partnership entity, trust, pooled investment cycle, a vehicle, uh, onus,
व्हीकल मतलब साइकिल हाँ
onus, है ना वो
क्या कर रही है
onus है ना वो
हाँ
onus on the reporting company to identify a SBO and cause him to make declaration. The duty is on the reporting company to identify a SBO and cause such a SBO to make declaration in the prescribed form. As per subsection 5 of section 90, read with the amendment rules, every reporting company shall be given a notice in the form when for to any person, whether or not a member of the company whom the company knows or has reasonable cause to believe.
ये बैंक फोर लिखा था अपन ने कंपनी नोटिस देता है उसको पढ़ा है
To be a significant beneficial owner of the company, to be having knowledge of the identity of a significant beneficial owner or another person likely to have such knowledge, or to have been a significant beneficial owner of the company at any time during the 3 years immediately preceding the date on which the notice is issued, and who is not registered as a significant beneficial owner of with the company as required under this section. Maintenance of register of SBO and inspection thereof. According to the section 92 and section 93, read with rules 5, every company shall maintain a register of significant beneficial owner in form number Ben 3, which shall be open for inspection during business hours at such reasonable time of not less than 2 hours or every working days as the board may decide by any member of the company on payment of such fee as may be specified by the company but exceeding 50 rupees of each inspection. Application to the tribunal section 97. The company shall, where that person fails to give the company the information required by the notice within the time specified therein, according to the rule 7, notice shall be given in form number Ben 4 for providing the information within 30 days of the date of notice, or where the information given is not satisfied. Apply to the tribunal within a period of 15 days of the expiry of period specified in the notice for any order directing that the share in question be subject to the restriction with regard to transfer of interest, suspension of all rights attached to the shares and such other matters as may be prescribed.
ये नोट से अपन ने पढ़ा था याद है ना तुमको वो 30 दिन का कंपनी टाइम देता है फिर रिप्लाई नहीं दिया तो 15 दिन में ट्रिब्यूनल के पास चला जाएगा फिर ट्रिब्यूनल ऑर्डर पास कर दो 1 साल रुकेगा वो। 1 साल के बाद भी इसने नहीं दिया तो आईपीएफ में ट्रांसफर कर समझा ना उधर से ज्यादा अच्छा लिख पढ़।
No, upon restriction on the transfer of interest attached to the shares in question, suspension of the right to receive dividend or any other distribution in relation to the shares in question, suspension of voting rights in relation to the shares in question, any other restriction on all or any of the rights attached with the shares in question. Section 98 states that on any application made under subsection 7, the tribunal may, after giving an opportunity of being heard to the parties concerned, make such order restricting the rights attached with the shares within a period of 60 days of receipt of application or such other periods as may be prescribed. According to the section 99, company of the person aggrieved by the order of the tribunal may make an application to the tribunal for relaxation of or lifting of the restriction placed under Section 98 within a period of 1 year from the date of such order. Provided that if no such application has been filed within a period of 1 year from the date of the order, such shares shall be transferred without any restrictions to the authority constituted under subsection 5 of section 125, that is the Investor Education and Protection Fund Authority, in such manner as may be prescribed. Declaration by SBO under section 90. As regards declaration of SBO under section 90 rule 3 of SBO rules 2018 state as under every individual who is significant
But yeah, अच्छा
every individual who is
पढ़ना
every individual who is significant beneficial owner in a reporting company as on the date of commencement of the amendment rule 2019, that is 8/2/2019, is required to file declaration in form number Ben 1 with the reporting company within 90 days from such commencement. According to the rule 4, the reporting company shall be required to file a return in form number Ben 2 with the registrar in respect of such declaration within 30 days of its receipt from the SBA. Any individual who subsequently becomes a significant beneficial owner in the reporting company or whose significant beneficial ownership undergoes any change shall be required to file a declaration form number Ben 1 with the reporting company within 30 days of such acquisition or change. Explanation. If an individual becomes a significant beneficial owner in a reporting company or his significant beneficial ownership undergoes any change within 90 days of the commencement of the company's, then that is 8/2/2019, it shall be deemed that the such individual became the significant beneficial owner or any change therein happened on the date of expiry of 90 days from the date of commencement of said rules. The period of 30 days for filing will be reckoned accordingly.
समझा तुमको ये क्या इसको क्या बोलते हैं अपन ट्रांजिशन पीरियड एक अभी रूल आया 2019 तो उधर 30 डेज की जगह कितना है 90 डेज इतना एग्जाम के लिए एग्जाम्पल के लिए इंपॉर्टेंट है क्या जरा भी बट समझा ना फिर नॉन एप्लीकेबिलिटी पर करा
Non-applicability of SBO rules. Rule 8 of the companies states that the SBO rules shall not be made applicable to the extent of share of the reporting company is held by the Investor Education and Protection Fund Authority constituted under Section 125(5). It is holding reporting company provided that the detail of such holding reporting company shall be reported in form number Ben 2. The central government, state government, or any local authority, a reporting company or a body corporate or an entity controlled wholly or partly by central government and or state government, investment vehicles such as mutual funds, alternatives, investment funds, real estate investment trust, and the infrastructure investment trust registered with and regulated by the Securities and Exchange Board of India, an invested vehicle
इन्वेस्टमेंट व्हीकल
regulated by RBI, Insurance Regulatory and Development Authority of India, or Pension Fund Regulatory and Development Authority.
समझा तुमको इधर आओ नोट्स में कौन सा सेक्शन है सेक्शन नंबर 90 है ना 90 अपन ने होल्ड पे रखा था ना बाद में क्या था इधर लिखो किसको किसको एप्लीकेबल नहीं है ये प्रोविजन किसको किसको एप्लीकेबल नहीं है
गवर्नमेंट
पहला तो क्या था आईपीएफ में अगर किसी का शेयर जा रहा है तो भाई वो देख लेगा, उसको फिर एसबीओ का ये रूल नहीं। फिर बाद में होल्डिंग कंपनी रहता है, पता है, होल्डिंग है और कौन है, सब्सिडरी। तो इसने अगर बेन टू फाइल कर दिया आरोप के, तो इसको इसने नहीं किया तो चलेगा। समझा तुमको? फिर तीसरा सीजीएसजी लोकल अथॉरिटी, फिर इन्वेस्टमेंट फंड सब आ गया, और फिर लास्ट में कौन सा है, इन्वेस्टमेंट व्हीकल एज रेगुलेटेड बाय आरबीआई। समझा तुमको ये 5 एक्सेप्शन? किसको है पहला तो? आईबीएफ, बीएफ।
सेकंड होल्डिंग सब्सिडरी,
होल्डिंग ने कर दिया सब तो सब्सिडरी नहीं किया तो चलेगा। फिर गवर्नमेंट कंपनी, सीजी, एसजी या एलए, फिर इन्वेस्टमेंट फंड, लोकल अथॉरिटी, इसमें आरईआईटी आ गया, जो भी इन्वेस्टमेंट दिख गया, और लास्ट में क्या है, इन्वेस्टमेंट व्हीकल, जो आरबीआई ने बोला। अरे समझा तुमको ये एमसीक्यू के लिए मैंने जस्ट लिखा है, एक गापचे मारा मैंने। यानी रिपोर्टिंग बॉडी का कंट्रोल होल्डली और पार्टली, हाँ। और एक कौन, ये गवर्नमेंट आ गया और गवर्नमेंट कंपनी भी आ गया। समझा तुमको? और आगे पेनल्टी है आगे का।
Penalty for contravention by SBO. If any person fails to make a declaration as required under subsection 1, he shall be liable to a penalty of 50,000 rupees, and in case of continuing failure, with the further penalty of 1,000 rupees for each day after the first, during which such failure continues, subject to a maximum of 2 lakh rupees. Section 9010. By reporting company, if a company required to maintain register under subsection 2 and the file the information under subsection 4, or required to take in necessary steps under subsection 4.8, fails to do so or denies inspection as provided therein, the company shall be liable to a penalty of 1 lakh rupees, and in case of continuing failure, with a further penalty of 500 rupees for each day after the first, during which such failure continues, subject to a maximum of 5 lakh rupees, and every officer of the company who is in default shall be liable to a penalty of rupees 25,000, and in case of continuing failure, with a further penalty of 200 rupees for each day after the first, during which such failure continues, subject to maximum of 1 lakh rupees. Section 9011.
पेनल्टी याद करने का जरूरत है क्या? बट जो इम्पोर्टेंट मार्क करा है वो करने का पहले करने।
It is worth nothing that any contravention by company and officer in default of the provision of Section 90 and SBO rules is compoundable.
ये कंपाउंडेबल नॉन कंपाउंडेबल सब रहेंगे ना, तभी मैं बता।
Note, where any person willfully furnishes any false or incorrect information or suppresses any material information of which he is aware in the declaration made, shall be liable for punishment for fraud under Section 447, Section 9012.
गवर्नमेंट कंपनी को एग्जाम्पशन है अगर डिफॉल्ट नहीं किया। अभी पावर टू क्लोज रजिस्टर करो।
Power to close register. Power to close register of member or debenture holder or other security holder, Section 91. Section 91(1) deals with the time limits for which the respective register of member, debenture holders, and other security holders are allowed to be closed. Section 91(2) mentions the penalty for contravention of the provisions of subsection 1. Section 91(1) contains the following provisions. इसको बुलवाओ।
जल्दी जल्दी। अरे जल्दी करना, क्या टाइम पास कर रही है?
उसको भी 10
Closure closure period. A company closure period. A company sorry.
वैसे पढ़ देते हैं
Company may close its register of members or register of debenture holders or register of of other security holders for an aggregate period of 45 days in each year, but not exceeding 30 days at any one time.
ये समझा तुमको 45 डेज एक साल एक टाइम में 30 डेज से ज्यादा है फिर 7 दिन पहले न्यूज़पेपर में ऐड देना पड़ेगा
हाँ 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 हाँ
फॉरेन रजिस्टर बंद कर सकते हैं अबे हाँ कर सकते हैं पर उधर न्यूज़पेपर किस कौन से में ऐड देंगे पढ़ पढ़
Notice period. The respective register of members, debenture holders, or other security holders may be closed by giving minimum 7 days notice for such lesser period as may be specified by the Securities Exchange Board of India. For listed companies or those companies which intend to get their securities listed.
लिस्टेड कंपनी के लिए कम पीरियड भी सेबी ने अगर बोला तो फिर रूल 10 का
Rule 10 of Companies Management and Administration Rules 2014 specifies the manner of closure of registers as under. A company closing the register of members or the register of debenture holders or the register of other security holders shall give at least 7 days previous notice and in such manner as may be specified by SEBI if such company is a listed company or intends to get its securities listed by advertisement at least once in a vernacular newspaper in the principal vernacular language of the district and having a wide circulation in the place where the registered office of the company is situated and at least once in English language and in an English newspaper circulating in that district and having wide circulation in the place where the registered office of the company is situated and publish the notice on the website as may be notified by the central government and on the website, if any, of the company Rule 10(1). Exemption of private companies. Exemption for the private companies. It is to be noted that a private company has been exempted from issuing a public notice in newspaper provided it issues minimum 7 days notice to its members prior to closure of the register Rule 10(2).
ये समझा तुमको हाँ रे प्राइवेट कंपनी ने न्यूज़पेपर में नहीं दिया बट मेंबर को बता दिया तो चलेगा
Section 91 contains
लिखने का गरज है उधर नोट्स में लिखने का गरज है
And that was mostly our follow picture. Within 7 days, so we will and we will be able to do this.
इधर लिखा है इधर गया
I don't know if it's family.
इधर नीचे ऊपर नीचे मतलब ऐसा इधर समझा ना तुमको ये
7 दिन में नहीं दे पाए तो उसको कभी नोटिस देंगे
अरे 7 दिन में नोटिस नहीं दिया न्यूज़पेपर में तो चलेगा बट एटलीस्ट 7 दिन पहले मेंबर्स को तो पता नहीं ये पढ़
Section 91 contains penalty
गंदा है
provisions
गंदा होगा
as stated below. In case of contravention of provisions of Section 91(1), that is, if the respective register are closed without giving notice or after giving a shorter notice, then that is so provided or for a continuous or an aggregate period in excess of the specified limits. Section 91(2) states following penalty. The company and every officer of the company who is in default shall be liable to a penalty of rupees 5,000 per day, subject to a maximum of rupees 1 lakh, during which the register is kept closed. Note,
नोट अच्छा
the offense is a compoundable offense under Section 441 of the Companies Act 2013.
एनुअल रिटर्न याद है सबसे इम्पोर्टेंट कॉन्सेप्ट है
Annual return section 92 and 94.
बट
Provisions with regard to annual returns are contained in section 92 of the Companies Act 2013 and rules 11 and 12 of the Companies Management and Administration Rule 2014. As per Rule 11, every company shall file its annual return in form number MGT7 except one person company and small company.
वो किसमें फाइल करेगा
OPC and small companies shall file the
तो
annual
देख के बोला तुमने आगे बढ़
shall file a return from the financial year 2021 onwards in form number MGT 7A.
कंटेंट्स ऑफ एनुअल रिटर्न क्या है
Contains of annual return, form number MGT 7, form number MGT 7A for OPC and small company, signing of annual return, certification of company secretary in practice if required, placements on website.
जोरा जोर से पढ़
Filing of annual return with the ROC and penalty of for contravention. Contents of annual return. According to the section 92(1), every company shall prepare a return referred to as the annual return in the prescribed for containing
कंटेंट्स ऑफ एनुअल रिटर्न क्या आएगा शेयर होल्डर बड़ा केएमपी बड़ा कि सीएफओ बड़ा बिगर अरे हाँ है ना जब कुछ नहीं वो देखेंगे आगे पर
According to section 92, every company shall prepare a return referred to as the annual return in the prescribed form containing the particular as they stood on the close as they stood on the close in financial year regarding its its registered office, principal business activities, particulars of its holdings, subsidiary and associate companies, its shares, debentures, and other securities and shareholding pattern. C is omitted. Its members and debenture holders, along with changes therein since the close of the previous financial year. Its promoters, directors, key managerial personnel, along with changes therein since the close of the previous financial year, meeting of member or class thereof, board and its various committees, along with attendance details, remuneration of directors and key managerial personnel, penalty or punishment imposed on the company its directors or officers, and details of compounding of offences and appeals made against such penalty or punishment, matters relating to certification of compliance, disclosure as may be prescribed, details as may be prescribed in respect of shares held by or on behalf of the foreign institutional investors of and such other matters as may be prescribed.
ये लास्ट वाला पॉइंट बहुत इंपॉर्टेंट है।
Abridged
ये समझा ना, कभी कंटेंट ऑफ एनुअल रिटर्न क्वेश्चन पूछा तो तुम लोग लिख देंगे ना फटाफट।
abridged form of annual return in terms of second provisions to section 91(1), the central government may prescribe the abridged form of annual return for one person and a company and small company or and such other class or classes of companies that may be prescribed accordingly as per Rule 11(1). OPC and small companies shall file the annual return from the financial year 2021 onwards in form number MGT 78. Signing of annual return. The annual return
ये
shall be
इम्पोर्टेंट
signed
है इसका साइन।
by a director of the company and the company secretary, and in case there is no company secretary, by a company secretary in practice. In case of private company, clause G of subsection 1 of section 92 shall apply to private companies which are small companies as under. Aggregate amount से थोड़ा जरूर करूँ।
पढ़ना क्या जूम करने का तो
Aggregates amount of recommendation drawn by directors. Notification number GSR 6464 E dated 5/6/2015 as amended by notification number GSR 583 E dated 13 June 2017. Management and administration, however, in relation to OPC and small company, the annual return shall be signed by a company secretary or where there is no company secretary by the director of the company.
समझा ना ये तुम? वो लोग छोटे लोग हैं ना बहुत, किधर इतना खर्चा करें? फिर
Certification of annual return by company
ये
secretary
कौन से फॉर्म में देगा?
in certain cases.
सर्टिफाई कौन से फॉर्म में करते हैं? हाँ, एनजीटी कौन सा बोलो?
Section 92(2) read with Rule 11(2) of the Companies Management and Administration Rules 2014 provides that the annual return filed by a listed company or a company having paid up share capital of 10 crore or more or a turnover of rupees 50 crore or more shall be certified by a company secretary in practice, stating that the annual return discloses the facts correctly and adequately, and that the company has complied with all the provisions of the Companies Act 2013. Such certificate shall be in form number MGT 8. Printing of annual return on website. Every company shall place a copy of annual return on its website, if any, and the web link of such annual return shall be disclosed in board's report. Refer to section 92(3). In case of private company, for provision to subsection 1 of section 92, the following provisions shall be substituted, namely, provide that in relation to OPC and small company and private
ये क्या वो स्मॉल कंपनी और प्राइवेट कंपनी को ओपीसी और स्मॉल कंपनी को ना बोला, ठीक है? डायरेक्टर साइन करेगा तो चलेगा, लेकिन सब्जेक्ट को उसने डिफॉल्ट नहीं किया एनुअल रिटर्न और एफएस वही लिखा। दिख रहा है ना तुमको? आगे बढ़ो, आईएफएससी पढ़। अरे आईएफएससी
in case of specified IFSC public
और आईएफएससी को भी ये नहीं एप्लीकेबल है, ठीक है? आगे बढ़। टाइम लिमिट याद है तुमको कितना है? तो देखा तुम किधर से 60 डेज? हाँ, एग्रीमेंट तो 60 डेज किधर से? 60 डेज किधर से बता दो। एनुअल रिटर्न कभी फाइल करना है?
एनुअल रिटर्न लास्ट में
लास्ट में कभी, लेकिन
सितंबर तो होता है, सितंबर 30 सितंबर तक ये पहला वगैरह से है ना, जुलाई
क्या
39 के पहला
39
39 तारीख हवा में
बोल रहे?
तो पहला
कल ही पढ़ा
अभी नहीं होगा
क्या? अगस्त?
जुलाई 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 का लास्ट है,
पागल है क्या तुम?
जुलाई एंड से 31 जुलाई के एंड से
क्या था टाइम लिमिट? 60 days फ्रॉम? अरे इतना तो बोला। फाइनेंशियल ईयर?
अरे अरे यार सब क्या होते
अबे एजीएम से 60 days था आगे नहीं?
हाँ
फिर एजीएम बुलाया ही नहीं तो रीजन के साथ फाइल करना है। आप मजाक कर रहे पढ़। और एजीएम का एक्सटेंशन ले लिया तो फिर उधर से 60 days पढ़ आगे। चल पढ़
The
पढ़
limit for filing of annual return. A copy of annual return shall be filed with the ROC within 60 days from the date on which the AGM is held. Where no annual general meeting is held in any year, it shall be filed within 60 days from the date on which the AGM should have been held. Along with the reasons for not holding AGM, Section 92(4) Rule 12. Section 9 penalty for contravention. Section 92(5) specifies as under.
तो
If
ये
any,
लोग ने भी काला काला किया है तो ये पेनल्टी इम्पोर्टेंट है।
if any company fails to file its annual return under subsection 4 before the expiry of the period specified therein, such company and its every officer who is in default shall be liable to a penalty of 10,000 rupees, and in case of continuing failure, with further penalty of 100 rupees for each day during which such failure continues, subject to a maximum of 2 lakhs rupees in case of the company and 50,000 rupees in case of the officer in default. Section 92(6) specifies penalty in case of company secretary as a practice.
कितना है बताओ?
In practice,
कितना है? सीएस में गलत गलत दिया तो
उसका उसको से जो उन्होंने गलत गलत निकला मतलब उसके और खांचे में से 2 लाख रुपए था,
खांचे में से
मतलब गलत साइन जो करता है ना उसमें पैसा नहीं निकला, उसमें से 2 लाख रुपए।
उसमें से 2 लाख नहीं 2 लाख ही लगे।
हाँ मतलब वही हम दर बर्तों के सब बढ़ गए थे।
अरे वो तो मैंने तेरे को जस्ट एग्जांपल दिया था। बट
if a company secretary in practice certifies the annual return otherwise, then in accordance with Section 92 or the rules made thereunder, he shall be liable to a penalty of 2 lakh rupees.
मतलब छोटा बड़ा सीधा 2 लाख।
इधर एक बार पेनल्टी में ना कंपनी और ऑफिसर इन डिफॉल्ट का पेनल्टी लिखो। कंपनी एंड ऑफिसर इन डिफॉल्ट का पेनल्टी क्या था? 10,000। ठीक है। कंटिन्यूइंग डिफॉल्ट के केस में कितना था? 100 रुपीज पर डे। और मैक्सिमम कितना बताओ? कंपनी के केस में कितना? 2 लाख। और ऑफिसर इन डिफॉल्ट के केस में 25 था कि 50 था? 50,000। ये लिखो है, ये इम्पोर्टेंट है भाई। समझा ना तुमको? ये 10,000 कंटिन्यूइंग डिफॉल्ट में
100 रुपीज पर डे,
मैक्सिमम कितना? तो क्वेश्चंस आता है पर डाउट नहीं में पूछेगा लेक्चर आने का उसका पर
Big Fox Entertainment Limited called its annual general meeting on 30th September 2021 for laying down the financial statements relating to the financial year ended 31st March 2021 for approval of its shareholders and conducting of other requisite businesses. However, due to want of quorum, the meeting could not take place and was cancelled. The company did not file the annual return for the year ending 31st March 2021 with the jurisdictional registrar of companies. Till the date, the directors are of the view that since the AGM did not take place, the period of 60 days from filing the annual return is not applicable, and thus there is no condition of Section 92.
बराबर है डायरेक्टर?
Right.
हाँ?
Right.
वो आंटी क्या किधर खोई है? ये पढ़ रही थी तभी ध्यान नहीं था तेरा? डायरेक्टर सही है?
Right.
क्या? कब तक हो जाना चाहिए?
60 days from AGM.
60 डेज 30 सितंबर से 60 डेज हो जाना चाहिए।
हाँ.
नहीं हुआ तो रीजन के साथ फाइल तो करना है रीजन के साथ। तो इधर से 60 डेज क्या आएगा? 29 नवंबर।
हाँ.
मैंने भी वही एग्जांपल लिया। बट
The contention of directors is incorrect if they are of the view that there is no contravention of the provisions of the Companies Act 2013, Section 92 states that every company has to file an annual return with the ROC within 60 days from the date on which the AGM is held, or where no AGM is held in any year, it shall be filed within 60 days from the date on which the AGM should have been held, along with the reasons for not holding the AGM. In above case, the AGM should have been held by 30th September 2021 but did not take place for want of quorum. Even if it was not held, Big Fox Entertainment Limited was required to file annual return within the specified time along with the reason for not holding the AGM. By not filing annual return, the company has contravened the provisions of section.
इधर तुमको पेनल्टी याद रहेगा और लिखोगे तो अच्छा इंप्रेशन पड़ेगा कि नहीं? कोरम क्या है बताओ? प्राइवेट कंपनी के लिए कितना है?
2.
और पब्लिक के लिए?
1000 का 5, 1000
एक मिनट एक 10 से
1000
5
हाँ.
फिर
1001
1 से 5000 15.
15 5000 था कि 10,000?
5,000. More than 5,000 लेगा तो 30.
बट
Place of keeping and inspection of registered
ये
return
किधर रखेंगे?
Register
आरओ या तो दूसरी जगह पे एसआर पास किया और उधर 110
City town village या मेरे से
और मोर देन 110 रिसेट हो गया।
वहाँ पे
बट
place of keeping registered.
ये कौन सा सेक्शन है? 94। मैंने बताया था वो 88 में तो अपन ने पढ़ा था लेकिन उसमें 92 इंक्लूड नहीं किया था। प्रोविजन सेम है तो इसमें 88 भी आ गया और 92 भी आ गया। पर
Registered office.
ये इतना ही पढ़। हाँ वही 2 एरो।
Registered office can also be kept at a place in India other than registered office where more than 1/10 of total members reside if approval by passing a special resolution.
इंस्पेक्शन के लिए खुला रहेगा।
business hours.
Inspection of registers, etc. According to Section 94(2), the registers and their indices, except when they are closed, and the copies of the return of all the returns
ये
shall
पता है ना
be
तुमको?
for inspection.
मेंबर को फ्री में और बाकी के लिए फीस लगेगा।
हाँ.
By any member, debenture holder, other security holder, or beneficial owner during business hours without payment of any fees, and by any other person on payment of such fees as may be prescribed. As per Rule 14.1, the register and indices are maintained pursuant to Section 88 and copies of returns prepared pursuant to Section 92 shall be open for inspection during the business hour at such reasonable time on every working day as the board may decide. By any member, debenture holder, other security holder, or beneficial owner without payment of fee, and by any other person on payment of fee as may be specified in the AOA of the company, but not exceeding 50 rupees of each inspection.
ठीक है 50 रुपया ऐसा दे के अपन ले सकते मैक्सिमम 50।
Explanation. For the purpose of this sub rule, reasonable time of not less than 2 hours on every working day shall be
ये
considered
तो
by
पता है ना तुमको, कम टाइम तक खुला रख सकते हैं, लेकिन दो
Minimum 3 hours.
तो
2 hours.
फिर पे निकल
2 hours. 2 hours.
Exact
What
पर
are the 2 hours? No, I think.
फटाफट पढ़े टाइम पास.
extracts of register of index according to section 94(3) read with rule 14(2). Any member, debenture holder or security holder or beneficial owner or any other person can take the extracts without payment of any fee, or can also get copies thereof with payment of fee not exceeding rupees 10 for each page. Such copies or entries or returns shall be supplied within 7 days of the deposit date, provided that such particulars of the register of index as written as may be prescribed shall not be available for inspection under subsection 2, or for taking extracts or copies with under this subsection. As per Rule 14, notwithstanding anything contained in sub-rules 1 and 2, the following particulars of the register of index or return in respect of the members of the company shall not be made available for any inspection under subsection 2 or for taking extracts or copies under subsection 3 of section 94, namely the address or registered address in case of the body corporate, email ID, unique identification number, PAN number.
पेन नंबर लिखते क्या? नहीं, पेन लिखते.
I will have one this.
समझा ना तुमको पेन क्यों लिखते? पेन का फुल फॉर्म बता प्रियंका.
Permanent count.
तो प्रियंका है परमानेंट. अबे अकाउंट नंबर गधी. ऑथेंटिकेशन मतलब खुद का फुल फॉर्म. परमानेंट अकाउंट नंबर बोल दो. हाँ, तो परमानेंट अकाउंट नंबर में आ गया ना नंबर एन, तो नंबर नंबर कैंसिल हो जाता है ना, इसलिए पेन लिखने का कभी पेन बोलने का. पढ़.
Prevention of register of members, etc., and annual return. As per second provision of section 94(1), the period for which the register's returns and records are required to be kept shall be kept at shall
ये
be
कितना कब तक संभाल के रखेंगे? परमानेंटली. अरे हाँ है ना. और डिबेंचर होल्डर के केस में 8 इयर्स. डिबेंचर होल्डर के केस पे फ्रॉम डेट ऑफ रिडेम्पशन. हाँ, फिर किसके किसके कस्टडी में रखेंगे? पढ़ फटाफट पढ़.
previous
प्रिजर्वेशन.
preservation of register of members. The register of members along with the index shall be preserved permanently and shall be kept in the custody of the company secretary of the company or any other person authorized by the board for such purpose. Preservation of register of debenture holders, security holders. The register of debenture holders or any other security holders along with the index shall be preserved for period of 8 years from the date of redemption of debenture or security as the
पर
case
डेट
may
ऑफ
be.
रिडेम्पशन हाँ, क्लोज ऑफ फाइन ऐसा एमसीक्यू देंगे जानबूझ के. 8 इयर्स फ्रॉम डेट ऑफ रिडेम्पशन, 8 इयर्स फ्रॉम 8 इयर्स वो फाइनेंशियल ईयर खत्म होने के बाद, 8 इयर्स फ्रॉम फलाना और 8 ईयर फ्रॉम डिमका. अपन कौन सा करने का? 8 इयर्स फ्रॉम रिडेम्पशन. इसमें दिमाग मत लगा ना. क्लोज ऑफ फाइनेंशियल ईयर से मार्क मत कर. एक्स्ट्रा बुद्धि लगाना मत. पर
And shall be kept in the custody of the company secretary
जून नहीं, तुम्हारी ही बात कर रहे हैं.
or any other
वो लोग का
person
एमसीक्यू नहीं है.
such so
और मैं इसलिए भड़क रहा हूँ क्योंकि ये अपने को 100 मार्क का थे, ये लोग को ये सब 40 मार्क का थे. पढ़.
preservation of copies of documents filed with ROC, copies of all annual returns prepared under section 92, and copies of all certificates and documents required to be annexed thereto shall be preserved for a period of 8 years from the date of filing with the ROC. Preservation of foreign register of members. The foreign register of members shall be preserved permanently unless it is discontinued and all the entries are transferred to any other foreign register or to the principal register. Foreign register of debenture holders or any other security holder shall be preserved for a period of 8 years from the date of redemption of such debenture or security. The foreign register shall be kept in the custody of the company secretary or person authorized by the board. Penalty for refusing the inspection or making any extract or copy required. If any inspection or the making of any extract or copy required under this section is refused, the company secretary and every officer of the company who is in default shall be liable for each such default to a penalty of ₹1,000 of every day subject to a maximum of ₹1 lakh during which the refusal or default continues. Section 94. The central government may also, by order, direct an immediate inspection of the document or direct that the extract required shall forthwith be allowed to be taken by the person requiring it. Section 94.
इधर कॉपी रजिस्टर कॉपी नहीं दे रहे तो इधर अपन किसके पास जाते हैं? सीजी भाई के पास जाते हैं, याद रखो। बाकी मम्मी के पास जाते हैं, इधर भाई के पास जाते हैं।
Powers are
हाँ ठीक है, डेलीगेटेड टू आरटी।
registers etc. to be evidence. Section 95.
ये तो एक लाइन का सेक्शन था जो रजिस्टर में लिखा है प्राइमा फेसी, हम लोग उसको
According to Section 95, the registers indices and copies of annual returns shall be prima facie evidence of any matter directed or authorized by to be inserted therein by or under this act.
ठीक है, ये सेक्शन आएगा 10 मार्क पे, है ना? 10
Requisites of a meeting.
मीटिंग।
Before we move on to our next concept of types of meetings and other procedures, to convene them as per the Companies Act 2013, let us understand the terms which are important to know for convening a meeting.
रेडी
Notice of
ये
meeting.
लोग ने एक ढांचा बनाया, स्ट्रक्चर। पहले नोटिस जाए,
Explanatory statement to be
इसके साथ एक्सप्लेनेटरी स्टेटमेंट आती है।
Section 1 of 2.
फिर ड्यूरिंग मीटिंग कोरम रहेगा,
During meeting,
चेयरपर्सन रहेगा, उसका सेक्शन लिखा है।
chairman.
चेयरपर्सन बोला,
Same
हाँ शीमेल क्या?
same like a chairman.
प्रॉक्सीज, फिर लेक्चर देख, लेक्चर वोटिंग और फिर क्या? रेजोल्यूशन, याद है? फिर बाद में मिनट्स ऑफ मीटिंग बनाएंगे, लास्ट में इंस्पेक्शन के लिए चालू रखेंगे और क्या करेंगे? मेंटेन करेंगे। जनरल मीटिंग मतलब क्या? एजीएम या ईजीएम। बोर्ड मीटिंग मतलब बोर्ड ऑफ डायरेक्टर्स का मीटिंग। क्लास मीटिंग मतलब कोई कुछ बुला रहा है, डिबेंचर होल्डर, पता है? डिबेंचर में पढ़ा था 110 वाले पेड अप शेयर कैपिटल नहीं रे, डिबेंचर होल्डर पेड अप शेयर कैपिटल नहीं होते थे। चलो ये वाला पढ़ फटाफट। एक एक मिनट। हाँ तो कल पहले के सेक्शन लास्ट में पढ़ाया ना मैंने। पढ़
General meeting. It is a meeting of shareholders of a company to be held as per the provisions of Act. The general meeting can be an annual general meeting or an extraordinary general meeting. An annual general meeting.
एनुअल मीटिंग का सेक्शन
96
और ईजीएम का
102 101 102 101 सॉरी 101
घर पे निकल
ईओजीएम ना एक्स्ट्राऑर्डिनरी
ईजीएम बोला तो भाई नहीं, ईओजीएम बोलना जरूरी है क्या? ईजीएम कौन सा सेक्शन है?
100
ईओजीएम मैंने क्यों लिखा था? याद रखने के।
भाई
पढ़ पढ़।
An annual general meeting is mandatory yearly gathering of company's shareholders. The objective of holding of an AGM is to provide an opportunity to members to discuss the functioning of the company and to take steps to protect their interests.
अच्छा
They can discuss any matter relating to the conduct of the affairs of the company. An EGM can be defined as a meeting of shareholders which is not an AGM. The objective
क्या
क्या कर रही हूँ?
अरे नहीं मैं ये पढ़ के हंसा
The objective of the holding an EGM is to discuss any matter of urgent importance which cannot be postponed till the next
नेक्स्ट
AGM.
बराबर ना एजीएम साल में एक बार होता है कुछ अर्जेंट डिसीजन लेना है तो
Board.
ये अफेयर्स ऑफ अ कंपनी मतलब क्या कंपनी आर्टिफिशियल पर्सन है उसका और किसी और कंपनी का फिर वैसा नहीं है तुम कुछ भी सोच सकते हो बोला वो तो आर्टिफिशियल है उसका हो सकता है
Board meeting, it is a meeting of board of directors of a company. Class meeting, it is a meeting of particular class of person like creditors, shareholders, debenture holders, etc.
द प्री रिक्विजिट
The prerequisites of the meeting are in general public applicable to all kinds of meetings, although the time limits may differ and there might be a specific mention of a certain type of meeting in respective section.
101 पढ़ा था अपन ने आया ना तो बोलो
हाँ पढ़ा था
मैं तो पढ़ा देगा वापस में
नो नो कर दिया उससे नोटिस ऑफ मीटिंग कर दी नोटिस कर दी
पढ़
जरूर चला अभी भी नहीं चला हाँ
वे आगे का पढ़
Authority to
अबे 101 हो गया तो 100 फिर दिमाग
explicit
क्या है
statement to be annexed to notice section 1 or 2. यार लग गया तो कर
2 मिनट का ब्रेक ले गया
हाँ. The annual general meeting of Green Limited was held on 31st August 2022. Suppose the chairman of the company after 2 days of AGM went abroad
बाय
for next 31 days due to unavailability of the chairman within time period prescribed for submission of copy of report of AGM with the register. The report as required was signed by 2 directors of the company, of which one was additional director of the company. Comment on the signing of this report of AGM.
सही है क्या सही है भाई एनुअल रिटर्न का साइनिंग में बोला भी पढ़ा थे बहुत इंपॉर्टेंट है कौन साइन करता है जरा बताओ तो
कंपनी सेक्रेटरी
कौन साइन करता है डायरेक्टर एंड कंपनी सेक्रेटरी और वो नहीं रहेगा तो सीएससी इन प्रैक्टिस हाँ
हाँ
बराबर अभी इसमें 2 सादे डायरेक्टर ने किया चलेगा
नहीं सर
नहीं चलेगा तो ये वाले ऑप्शन तो कट होगा बराबर अभी नो वाले 2 आंसर पर
No, the signing in is not in order as only the chairman is authorized to sign the report. No, the signing is not in order since in case if the chairman is unable to sign, the report shall be signed by 2 directors of the company. One
अरे सॉरी ये अलग है पढ़
who shall be the managing director if there is no and company secretary of the company.
कौन साइन करता है कंपनी से सॉरी चेयरपर्सन साइन करता है वो नहीं रहेगा तो एक डायरेक्टर
मैनेजिंग डायरेक्टर
2 डायरेक्टर रहना चाहिए उसमें से एक एमडी है तो ठीक है कौन सा आंसर देख लेते एक बार नेक्स्ट पार्ट नेक्स्ट पार्ट
तो माइक पे क्यों बोलता है?
मेरा आवाज नहीं है ना इसके लिए पढ़
The AGM shall be called by giving 21 clear days
एक इसका है
notice. However, it can be called by giving shorter notice if members entitled to vote at that meeting give their consent in writing or by electronic mode. In such cases, how many members have to give their consent?
बताओ
95%
91 है कि 90 है बताओ
95 सर 90 या 95 यही है स्पेशल 95 95
बिना देखे बोलो रे
95% सर
देखा ना तूने?
7 करोड़
यही एक इम्पोर्टेंट है भाई, 95% है ये केस में।
सर बोल रहे थे 7 करोड़
7 करोड़ के ऊपर पागल, इतने से 7 करोड़ पागल है क्या? बट
आपको अडेप्टर लेके
नहीं, जरा भी नहीं।
which among the following companies is not required to provide its members the facility to exercise right to vote by electronic mode under the provisions of the Companies Act 2013?
एक्सेप्शन से हो गया
बड़ा आंसर आता है तेरे को?
We Limited, whose equity shares the companies having both equity as well as preference shares are listed on a recognized stock exchange.
लिस्टेड कंपनी है, उसको तो एक्सेप्शन आएगा क्या कभी जिंदगी में? आगे बढ़।
A limited whose equity share only type of shares the company is having are listed on recognized stock exchange. C Limited whose preference share the company is having both equity as well as preference shares are listed on a recognized stock exchange. D Limited whose equity shares are as well as preference shares are listed on the recognized stock exchange.
इसका आंसर क्या है भाई? सी है। हाँ, इसको याद रखना। अरे कुछ नहीं, इधर इक्विटी शेयर लिस्टेड है, इधर भी इक्विटी शेयर लिस्टेड है, इधर भी इक्विटी शेयर लिस्टेड है, इधर प्रेफरेंस शेयर है। इसमें लिखा है कंपनी के पास दोनों कैपिटल है, लेकिन प्रेफरेंस शेयर लिस्टेड है, उसको गरज नहीं। पर ऐसा एमसीक्यू आता है।
Descriptive questions.
अंगड़ाई मत ले, तो अच्छे से पढ़।
The general meeting of Alpha Software Limited, the chairman directed to exclude certain matters detrimental to the interest of the company from the minutes. Mukesh, a shareholder, contended that the minutes of the meeting must contain fair and correct summary of the proceedings. Thereat, decide whether the contention of Mukesh is maintainable under the provisions of Companies Act 2013.
बताओ। अरे क्वेश्चन पढ़ते वक्त किधर ध्यान दे रहे हो? मोबाइल रख देना साइड में, साइड में रख उसको। वो क्वेश्चन पढ़ रही है, एक तो हलक डुलक करके, और वो भी ध्यान नहीं दे रहे तुम। ऐसा 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 पढ़। क्वेश्चन समझा क्या तुमको? चेयरपर्सन है, उसको कुछ हटाना है मिनट्स ऑफ मीटिंग में से, हटा सकता है?
हाँ हटा सकता है पर सर वो अगर ये अगर उसको irrelevant लगा तो ना
हाँ, तो उसने लिखा है ना, डेटा डेट्रीमेंटल टू द इंटरेस्ट ऑफ द कंपनी।
हाँ कर सकता है
सोल पावर किसके पास है? चेयरमैन के पास है। वो कर सकता है कि नहीं?
मुकेश गलत है ये बात।
मुकेश गलत है। क्यों? क्योंकि मुकेश को हो गया कैंसर। इसको समझा देगा। नहीं नहीं, छोड़ो।
किसी का वो वाला है
चल चल चल, कल अपन जाएंगे, डोंट वरी। अगर कल सर नहीं लेके गए ना, तो उसको बोलेंगे हमको भेज भाई, हमको नहीं पता। किधर जाओ, किधर जाओ? अरे सब लोग जा रहे हैं, आज नहीं या तो कल जाएंगे, पर
ये ऊपर है, उनके ऊपर।
उनके ऊपर है ना, सवाल फ्री में वो लेके जाते।
अपने
अपने सुनो।
मेरे ऊपर रहेगा तो भाई मैं रात को ही लेके जाऊंगा, इररिलेवेंट टाइम पे लेके जाएगा, जब भी लेक्चर नहीं रहेगा। पर
मेरे को लगा जब भी कोई अवेलेबल नहीं रहेगा।
मूवी डाल रहे हैं
Section 118(5) of the Companies Act 2013 there shall not be included in the minutes of meeting any matter which, in the opinion of the chairman of the meeting,
डिफेमेटरी या तो इररिलेवेंट इमटेरियल है या तो इंटरेस्ट ऑफ द कंपनी
further under section 118(6), the chairman shall exercise absolute discretion.
ठीक है डिफेमेटरी इमटेरियल इररिलेवेंट है या तो डेट्रीमेंट डीआईडी भी रख सकते हैं
In regard the inclusion or non-inclusion of any matter in the minutes of the grounds specified in subsection 5 of the section 180. Hence, in view of the above, the contention of Mukesh, a shareholder of Alpha Limited, is not valid because the chairman has absolute direction on it.
अरे समझा तुमको इजी था
चलो वहां पे मुझे बोल रहे ना कि उसको फेयर ये देना चाहिए वो उनके ऊपर तो अगर सबको ऐसा प्रूव कर
अरे पर डिफेमेटरी लग रहा है तो होल एंड सोल पावर किसके पास है चेयरमैन
चेयरमैन के पास है, पर अगर वो करने लगे ये लोग काम की चीजें वो भी निकाल दे रही थी
तो फिर देखा जाएगा
तो हो सकता
बट जनरली पावर चेयरमैन के पास ही है
है बस पढ़ आगे पढ़
A general meeting was scheduled to be held on Friday, 15th April 2022 at 3 p.m. As per the notice, the members who are unable to attend the meeting in person can appoint a proxy, and the proxy forms duly filed should be sent to the company so as to reach at least 48 hours before the meeting. Mr. X, a member of the company, appoints Mr. Y as his proxy, and the proxy form dated 9/4/2022 as deposited by Mr. Y with the company at its registered office on 11 April 2022. Similarly, another member, Mr. W, also gives two separate proxies to two individuals named Mr. M and Mr. N. In the case of Mr. M, the proxy dated on 12th April 2022 was deposited with the company on the same day. And the proxy form in favor of Mr. N was deposited on 14th April 2022. All the proxies, Y, M, and N, were present before the meeting. According to the provisions of the Companies Act 2013, who would be the person allowed to be present as proxies of members X and W respectively?
बताओ इसको इम्पोर्टेंट मार्क करना मैं एटीसी स्पेशल एलडी आ रही बवाल एलडी क्वेश्चन समझा क्या तुमको पहले क्या बोला कंपनी ने बोला है 48 आवर्स पहले तक हमको पहुंचना चाहिए ठीक है तो कौन मेंबर कौन है एक्स है उसने किसको रखा है वाई को रखा है और इसका 11 अप्रैल को आ गया इसका सॉर्टेड है सिमिलरली कौन है डब्ल्यू उसने दो प्रॉक्सी बोले एम और एन ठीक है एम के केस में 12 तारीख को हुआ 12 को पहुंचा इसका 14 को पहुंचा ठीक है तीनों प्रेजेंट है तो बताओ एक्स के लिए कौन रहेगा वाई और डब्ल्यू के लिए एम क्योंकि ये 14 है 15 मतलब 15 तारीख को तो मीटिंग है तो ये क्या बोलते हो अरे हाँ है ना समझा तुमको ये मेरे को और एक बोलने का है कि अगर पढ़ के अभी मेरे को और एक पूछने का है समझो प्रॉक्सी रखा था मैंने कौन ये मैंने बताया नहीं था प्रॉक्सी रखा था मैंने और मैं कौन है मेंबर ठीक है मीटिंग में हम दोनों पहुंचे ठीक है तो कौन वोट करेगा ये जनरल नॉलेज का था क्वेश्चन नंबर कौन सा था पढ़ जरा किधर गई ये क्यों नहीं ये ज्यादा हो जाएगा तू क्या कर रही है अंदर सिंगापुर पानी में डूब गई पुल तेरी यार।
मिलाकर वो सुई ऐसे
चल पढ़। एक मिनट। हाँ, बहुत जल्दी याद दिलाया तुमने। पढ़।
A proxy is an instrument in writing executed by a shareholder authorizing another person to attend a meeting and to vote thereat on his behalf. In this absence, as the provisions of Section 105 of the Companies Act 2013, every shareholder who is entitled to attend and vote has a statutory right to appoint another person as his proxy. It is not necessary that the proxy be a member of the company. Further, any
लेकिन निधि के केस में मेंबर ही होना चाहिए, याद है तुमको? पढ़।
any provision in the articles of association of the company requiring instrument of proxy to be long with the company more than 48 hours before a meeting shall have effect as if 48 hours had been specified therein. The members have a right to revoke the proxy authority by voting himself before the proxy has voted, but once the proxy has voted, the member cannot retract his authority. When two proxy instruments by the same shareholder are logged in such a manner that one is logged before and the other after the expiry of the date fixed for lodging proxies, the former will be counted.
फॉर्मर मतलब पहला की बाद में।
पहला. Thus, in case of member X, the proxy Y will be permitted to vote on his behalf, as form for appointing proxy was submitted within the permissible time. However, in case of member W, the proxy M and not proxy N would be permitted to vote
पढ़ ही लेना।
as the proxy authorizing N to vote was deposited in less than 48 hours before the meeting.
ऊपर आने का ऊपर। समझा ना तुमको ये? पढ़ आगे।
Mr. H. Mechanics Company Limited served a notice of general meetings upon its shareholder.
इधर ध्यान दो ना, क्वेश्चन पढ़ रहे।
The notice stated that the issue of sweat equity shares would be considered at such meeting. Mr. A, a shareholder of the MH Mechanics Company Limited, complains that the issue of sweat equity shares was not specified fully in the notice. Is the notice issued by MH Mechanics Company Limited regarding issue of sweat equity shares valid according to the provisions of the Companies Act 2013 explained in detail? Huh?
क्वेश्चन समझा तुमको?
वापस कर दिया?
नहीं। क्या एमएच ने बोला कि हम लोग स्वेट इक्विटी शेयर डिक्लेयर करने वाले। ठीक है, एक शेयर होल्डर क्या बोलता है कि तुमने बताया नहीं बराबर से, सब डिटेल में नहीं बताया। ठीक है, तो ये वैलिड है कि नहीं? आंसर दे। क्यों? इसमें सब डिटेल बताना चाहिए ना, एक्सप्लेनेटरी स्टेटमेंट और सब। 102 पढ़ा था अपन ने, नोटिस के साथ ये भी जाता है।
Under Section 102, 2B of the Companies Act 2013, in case of any meeting other than an annual general meeting, all business transacted there and shall be deemed to be a special business. Further, under Section 1021, a statement setting out of the following material facts concerning each item of special business to be transacted at a general meeting shall be annexed to the notice calling such meetings. The nature of concern or interest, financial or otherwise, if any, in respect of each items of every director and the manager, if any or other KMP and related to such person, and any other information and facts that may enable members to understand the meaning, scope and implication of the items of business and to take decision thereof. Thus, the objection of the member is valid since the complete details about the issue of validity were required to be sent with the notice of the meeting. The notice is therefore cannot be said to be a valid one when the provisions of Section 102 of the Companies Act 2013 are considered.
भाई समझा ना तुमको? ऑर्डिनरी बिजनेस कौन सा होता है?
ordinary issue अपना financial statement, board meeting और auditor report. Board report, auditor report, declaration of dividend, या फिर appointment of director in place of retiring director, or appointment of auditor and fixing of remuneration.
पढ़
My answer is also the same.
पढ़ फटाफट।
Tulip Gardens Limited maintains in register of members at the registered office in Mumbai. A group of members residing in Kolkata wants to keep the registered of members at Kolkata. Keeping in view the provisions of the Companies Act 13, explain whether Tulip Gardens Limited can keep the registers at returns at Kolkata.
रख सकता है क्या कोलकाता में
ऐसा
SR
हिसाब देना
और कोलकाता में 110 more than 110 था इधर इक्वल टू नहीं है
हाँ
इधर इक्वल टू नहीं है इधर more than 110
हाँ
और नेक्स्ट वर्ड वेदर मिस्टर रिच अ डायरेक्टर होल्डिंग ओनली 400 shares has right to inspect register of member
हाँ
है ना
yes
अरे होल्ड कर सकते
yes
सकता है मेंबर
yes
फटाफट देखा दो प्रोविजन पूछ लेते साथ में तुमको पता है आजकल पेपर कैसा बनाते हैं पता है एक ही क्वेश्चन केस स्टडी रहेगा उसमें 2 एक्ट का इम्प्लीकेशन पूछेगा ये वाला भी और ये वाला भी बट तुम छोटे हो पढ़ आगे
Maintenance of the registers of members, etc. As per section 94(1) of the Companies Act 2013, the registers required to be kept and maintained by a company under section 88 and copies of the annual return filed under section 92 shall be kept at the register office of the company. Provided that such registers of copy of return may also be kept at any other place in India in which more than 1/10 of the total number of members entered in the register of members reside. If approved by SR, passed in a general meeting of the company. So Tulip Limited can also keep the registers and returns at Kolkata after the compliance with the above provisions, provided more than 1/10 of the total number of members entered in the register of members residing in Kolkata. As per section 94(2) of the Companies Act, the registers and their indices, except where they are closed under the provisions of this act, and the copies of all the returns shall be open for inspection by any member, debenture holder, other security holder, or beneficial owner during business hours. Without payment of any fees or by any other person on payment, such fees as may be prescribed. Accordingly, a director, Mr. Rich, who is a shareholder of the company, has a right to inspect the register of members during business hours without payment of any fees as the provisions of this section.
ठीक है वो लोग ने अच्छे से लिखा है फीस भी देने का जरूरत नहीं कोई अगर कोई डिबेंचर होल्डर या कोई और क्रेडिटर होता तो
फीस देना पड़ेगा
फीस है
डिबेंचर होल्डर को
सॉरी डिबेंचर होल्डर को फ्री कोई और अदर पर्सन अदर देन मेंबर नेक्स्ट पढ़ इधर से पढ़
The Board of Directors of Share Transporters and Logistics Limited called an extraordinary general meeting upon the requisition of members. However, the meeting was adjourned on the ground that the quorum was not present at the meeting, advised the company.
बता
किचन हो गया तो फिर
अगले दिन रखेंगे
नेक्स्ट वीक
अगले दिन
अगले हफ्ते में
एडजन हो गया नेक्स्ट वीक सेम डेट सेम डे सेम टाइम सेम
हाँ,
प्लेस
सेम प्लेस
अगर वहां पे भी करने एडजन हो गया तो
जितने जब प्रेजेंट रहेंगे उतने में खत्म करने का
सब यही भूतियागिरी करेंगे यही भूतियागिरी
मतलब
क्या बोला है?
कैसी
किसने बोला है रिक्वेजिशन ने मेंबर मीटिंग बोला है
तो वही लोग मानते
हाँ।
हैं
कैंसल हो जाएगा भाई कैंसल हो जाएगा रिक्वेजिशन ने बोला ईजीएम बोला और वो ही नहीं आ रहा ये क्या पूछेगा
ओके
नॉर्मल मीटिंग रहेगा तो वो एडजन वेजन सब इतना डिटेल में लिख के आएगा और मार्क्स कितना मिलेगा
0
अरे समझा तुमको
हाँ।
किसने बुलाया रिक्वेजिशन ने बुलाया कि नहीं तो सीधा कैंसिल हो जाएगा भाई इधर एडजमेंट का केस ही नहीं है तुमको कुछ डिस्कस करना है और तुम ही नहीं आ रहे मतलब ये क्या बात है पढ़ ध्यान रखना इसको चाहिए तो टिक करके रखो एक सिंगल टिक
वो भी है
ये कौन सा क्वेश्चन था वैसे देखो मैं भी क्वेश्चन घर से पढ़ के नहीं आया हूँ ठीक है क्वेश्चन अपन साथ में ही सॉल्व कर रहे हैं बस अपने को अप्लाई करना है कॉन्सेप्ट पर
इनको उसमें केस सारा फिर जितने मेंबर आए हुए
वो तो
मान लेंगे
सादे मीटिंग में वो
दूसरा मीटिंग वाला पूरा वो
पढ़ आगे पढ़
According to section 102 of the Companies Act 2013, the Board of Directors must convene a general meeting upon requisition made by the stipulated minimum number of members. As per section 1032B of the Companies Act 13, if the quorum is not present within half an hour from the appointed time for holding a meeting of the company, the meeting, if called on the requisition of members, shall stand cancelled. Therefore, the meeting stands cancelled and the stand taken by the BOD to adjourn it is not proper and valid.
अरे समझा ना तुमको
हाँ।
ध्यान रखना है ये भाई नेक्स्ट पढ़ जसमीत को बोलना क्वेश्चंस देखने के लिए बोल
Zorab Garments Limited served a notice of general meeting upon its members. The notice stated that a resolution to increase the share capital of the company would be considered in such meeting. Roshni, a shareholder of the company, complained that the amount of the proposed increase was not specified in the notice. It is the notice.
बताओ वैलिड है नोटिस? नहीं है। एनी अदर बिजनेस इज अ स्पेशल बिजनेस और नोटिस भी जाएगा और 102 के हिसाब से एक्सप्लेनेटरी स्टेटमेंट भी जाएगा। 101 के साथ 102 फ्री। अरे हाँ है ना। चलो आंसर एक बार पढ़ लेते हैं। कौन सा क्वेश्चन था?
6 अंडर सेक्शन 102 और ऊपर क्या सर?
एक मिनट, ये वही आंसर है, इस पर पहला वाला आंसर ही है।
हाँ
वही लिखा है 102 वाला, तो मैं ये पढ़ रहा नहीं, थर्स कंक्लूजन पढ़ रहा हूँ। थर्स द नोटिस देयरफॉर इज नॉट वैलिड, ठीक है, कंसीडरिंग द प्रूफ। समझा ना तुमको? सातवां पढ़।
Examine the validity of the following decision of the board of directors with reference of the provisions of the Companies Act 13. In a annual general meeting of a company having share capital 80 members present in person or by proxy holding more than 1/10 of the total voting power demanded for poll. The chairman of the meeting rejected the request on the ground that only members present in person can demand for poll.
बोलो।
नहीं चले
बोल मतलब क्या?
हाँ चिट्ठी
चिट्ठी वाला
हाँ
है ना? पोल मतलब चिट्ठी वाला भाई, हाथ मतलब हाथ वाला, शो ऑफ हैंड।
शो ऑफ हैंड क्या बोलने का?
पोल मतलब हाथ खड़ा कर रहे तो अभी जाने में मेरे वर्ड आया था, बट ठीक है, समझा तुमको।
हाँ।
मैंने तुमको बोला था प्रॉक्सी कुछ नहीं कर सकता, लेकिन पोल में वो अपना पीपी याद रखना, प्रॉक्सी पोल में सब बोल सकते, पोल के लिए डिमांड कर सकता है वो।
हाँ।
तो ये बोलते हैं सिर्फ मेंबर है, मेंबर ही डिमांड कर सकते हैं, तो गलत है डायरेक्टर।
हाँ
फिर दूसरा क्वेश्चन पढ़, ये वाला पढ़।
In an annual general meeting during the process of poll, the members who were demanded for poll want to withdraw it. The chairman of the meeting rejected the request on the ground that once poll started, it cannot be withdrawn.
विड्रॉ कर सकते?
नहीं
कर सकते हैं यार, विड्रॉ कर सकते हैं कि नहीं? अभी हमको नहीं करना है, लेकिन कितने लोग एग्री होने चाहिए?
नहीं
90। कितने लोग एग्री होने चाहिए?
तो गलत बात में नहीं कर सकते ना।
नहीं
मैं कर सकते विड्रॉ
लिखवाया था।
पर कितना था? एक मिनट,
जैसे अभी क्यों रिजेक्ट द रिक्वेस्ट में withdraw.
पढ़ आगे, कुछ लिखा नहीं है, मतलब विड्रॉ कर सकते हैं। पढ़
क्वेश्चन लो,
ये
आंसर
पढ़।
पढ़ने का है। Section 109 of the Companies Act 2013 provides for the demand of poll before or on the declaration of the result of
तो
the
क्या कर रही है? ध्यान देना, जब आते सब लेक्चर में ही नहीं थी, बैठ जा, सो जा, कुछ काम की नहीं है। पर
result of the voting
बैठ
on
जा।
any resolution on show of hands. Accordingly, section 1091 lays down as under before or on the declaration of the result of the voting or any resolution of the show of hands. Oppose
उसमें अपन ने लिखा भी था नोट्स में कि चेयरमैन को लगता है वो मैटर पे पोल करेंगे या कुछ जो रिक्वेस्ट करेंगे, कितने रिक्वेस्ट करेंगे पर
A poll may be ordered to be taken by the chairman of the meeting in its own motion and shall be ordered to be taken by him on a demand made in that behalf. In that case of a company having a share capital by the members present in person or by proxy,
not less than 1/10
were allowed or having not less than 1/10 of the total voting power or holding shares on which an aggregate sum of not less than 5 lakh rupees or such higher amount as be prescribed has been paid up. And in the case of any other company by any member or members present in person or by proxy were allowed and having not less than 1/10 of total voting power.
इसमें मैंने तुमको बोला था इधर पेड अप शेयर कैपिटल का नहीं देखना है तुमको, 1/10 ऑफ टीवीपी देखना है और फिर 5 लाख।
हाँ
तो बुरा मान गए इसके।
हाँ
फिर विड्रॉ कर सकते सबसे।
विड्रॉ
देख कितना अच्छे से लोग ने प्रोविजन पहले समझा है, फिर कंक्लूजन दिया है। तुमको ऐसे ही लिखना है, तो मेरे को पूछता है ना कैसा लिखना, ऐसा ही लिखना।
withdrawal of the demand for poll. According to section 1092, the demand for a poll may be withdrawn by any time by the person who made the demand.
मतलब इनडायरेक्टली क्या बोलना चाहते हैं? 1/10 वाले ये करेंगे,
हाँ
पोल मांगेंगे, और 1/10 वाले विड्रॉ भी कर सकते हैं।
हाँ
मतलब जिसने मांगा है तुमसे, वो तुमसे वापस छीन भी सकता है। अरे हाँ,
सकते हैं
समझे तुम?
हाँ.
पढ़।
Hence, on the basis on the above provisions of the Companies Act 13, The chairman cannot reject the demand for such poll to the provisions contained in the articles of the company. The chairman cannot reject the request of the members for withdrawal of the demand for poll.
अरे समझा ना तुमको, तो दोनों केस में गलत था साला। पर नेक्स्ट क्वेश्चन,
Surya, a shareholder gives a notice for inspecting proxies. 5 days before the meeting is scheduled and approaches the company 2 days before the scheduled meeting for inspecting the same. What is the legal position in respect of demanding for inspection of proxies by Surya as per the provisions of the Companies Act 2013?
चलो बताओ। इंस्पेक्ट कर सकते हैं रजिस्टर ऑफ प्रॉक्सी,
हाँ, सकते हैं।
कुछ याद है तुमको? कर सकते हैं कितने टाइम के अंदर?
Business hours.
3 days before start.
3 days बिफोर था,
हाँ।
याद है कुछ?
हाँ,
24 घंटे के। पढ़ आंसर पढ़,
कुछ नहीं पढ़ा तो वो इंस्पेक्शन का
आंसर पढ़।
Under section 1058 of the Companies Act 13, every member entitled to vote at a meeting of the company or on any resolution to be moved thereat shall be entitled during the period beginning 24 hours before the time fixed for the commencement of the meeting and ending with the conclusion of the meeting. To inspect the proxies lodged at any time during the business hours of the company, provided not less than 3 days notice in writing of the intention. So to inspect is given to the company. In the given case, Surya has given a proper notice, therefore validity of notice cannot be denied. However, such inspection can be undertaken only during the period beginning 24 hours before the time fixed for the commencement of the meeting and ending with the conclusion of the meeting. In the view of above provision, Surya can undertake the inspection only during the above mentioned period and not 2 days prior to the meeting.
मतलब स्टार्ट भी 24 घंटे पहले ही होता है।
इधर दे, ये समझा क्या मैंने तुमको? इम्पोर्टेंट भी मार्क करा। क्या बोलता है? एवरी मेंबर इज एंटाइटल्ड, हु इज एंटाइटल्ड टू वोट, ठीक है, शैल बी एंटाइटल्ड ड्यूरिंग द पीरियड कभी बिगनिंग 24 आवर्स पढ़ना हो विद द कमेंसमेंट ऑफ मीटिंग एंड एंडिंग विद द कंक्लूजन, ठीक है। इंस्पेक्ट कर सकता है बिजनेस प्रोवाइडेड 3 दिन पहले उसने नोटिस दिया। मैं तुमको समझाऊँ क्या अच्छे से? हाँ बोल। हाँ, अपना मीटिंग कभी है? समझा या फिर भी वापस समझाने को? मीटिंग कभी है अपना? हाँ, 14 फेब को ही अपना मीटिंग का।
हाँ,
14 फेब को मीटिंग, ठीक है। अभी ये प्रॉक्सी वॉक्सी आए रहेंगे। अरे हाँ है ना।
हाँ,
प्रॉक्सी का मेरे को बात बता, कितने दिन पहले इंटीमेट करना पड़ता है? 48 आवर्स पहले,
हाँ,
ठीक है।
हाँ,
तो भाई 14 को अपना मीटिंग है, कितने बजे? 11 बजे। कितना बजे? 11 बजे। तो इधर से 24 आवर्स पहले तक वो इंस्पेक्ट कर सकता है, सब्जेक्ट टू उसने 3 दिन पहले नोटिस दिया। 3 दिन पहले क्या नोटिस दिया कि मेरे को देखने का।
इंस्पेक्ट कर लो।
अभी ये 24 आवर्स तक देख सकते हैं,
हाँ।
बराबर। तो मैंने ऐसा भी बोला था, ऐसा नहीं कि रात को 12 बजे देखने
हाँ,
चले जाओ
हाँ।
बिजनेस आवर्स में, ऐसा बोला था।
हाँ,
मतलब शॉर्ट में बोलो तो कभी 11 बजे से लेके 6 बजे तक देख सकता है 13 तारीख का।
हाँ।
अरे समझा? अभी क्लियर हुआ? तो ये देख सकता है ये पीरियड में, सब्जेक्ट टू इसने 3 दिन पहले का नोटिस दिया। अभी अपने केस में क्या हुआ था? कौन सा क्वेश्चन था?
नोटिस दिया 5 दिन पहले।
नोटिस फॉर 5 डेज एंड अप्रोचेस। अभी कभी आया 5 डेज पहले इसने नोटिस दिया, इधर वो राइट है, लेकिन देखने का भी चला गया 2 दिन पहले। ऐसा नहीं है, 24 घंटे पहले ही जा सकते। ये कभी देखने का भी चला गया 2 दिन पहले।